Good evening, everybody. It always makes me excited when I see them bringing in extra chairs. That's good news. So thank you for coming tonight and being part of the BECU Member Summit and coming to, I'm stepping back because I'm getting some feedback. Coming to our presentation on estate planning, what everyone needs to know. There's a lot of questions around this area and there's a lot of tools, and it's always nice to come together and talk about those so that you guys can be prepared and go out and get your documents in order so you can have the peace of mind knowing that you've made the right decisions and have everything in place for your loved ones. I'm Rochelle Chaplinsky. I'm the Business Development Officer with BECU Trust Services, and to my left is...
Hi, pleased to be here. My name is Neil Archibald. I'm General Counsel with Members Trust Company. We are a BECU partner. And we work very closely with the BECU team to provide trust and investment services to the Seattle community. So we're just really happy that you're out here. As Rochelle said, very happy to see all of the filled seats, and there's an obvious reason. Everybody requires planning. If you take the time to build your assets, then you want to have a thoughtful disposition of those assets. So we'll kind of cover the high ground today, and certainly as you are listening, please write down your questions, and we can certainly answer them at the end. And then if you have any more specific questions, definitely catch us after and take advantage of our presence. Thank you for coming.
And just a couple housekeeping items. If you have cell phones, if you can silence them, that would be great. Like Neil said, we're going to save questions until the end for the sake of time. And if you do need to use the restrooms, it's just out the door and to your left. So, the important pieces. So today, this evening, our agenda, we're going to talk about what an estate plan is, who needs an estate plan, planning for incapacity. We're going to touch on wills and probate, and then we're going to wrap it up by talking about trusts and giving you information on the different type of trusts and what they are and how they work. So what is an estate plan? It's a map. It's a map that has your instructions and information on it to talk about who you want to manage your personal affairs in case you become incapacitated or when you pass away. There's a lot of individuals out there who will say, I don't need an estate plan. I don't have enough money for a will. I don't need to do this. But it's not just for the wealthy. Even somebody who is fresh out of college, they have assets. They have needs. Even somebody later on in life who may not live at home on their own, they still have wishes that need to be carried out. Without an estate plan, you can't control what happens to your property or who it goes to if you pass away or if you become incapacitated. You get to make your wishes. You get to put them in writing. You get to clearly say who gets what, when they get things, and who's going to be responsible for passing those items on. And then you can preserve assets for your loved ones. If you have concerns, there's different tools and strategies to make sure that those loved ones are taken care of down the road when you're no longer able to. You especially need an estate plan if you have a spouse that is not comfortable with finances. I hear that a lot. I have a lot of individuals that come in and say, I handle the bills, I take care of all the finances. If something happens to me, my spouse is going to need help and they're not going to know how to manage or maneuver. If you have minor children, I have 2 young kids, so if something happened to me and my husband, I want to know who is going to be responsible for taking care of my kids and making sure that they're raised in a manner that I feel comfortable with. If you have a disabled beneficiary, there's different things that you need to take into account with that. They could have benefits. They could have medical needs that may need special planning and structuring in order to make sure that they're continued to be taken care of. And then if you own property in more than one state, there's strategies to that too, and to help streamline things and make things easier for the individual you're putting in charge to settle your estate. A lot of people will talk about, well, you know, when I'm gone, I don't worry about what's going to happen to me. I don't care what happens to my assets. That's fine. But they always forget what happens if you become incapacitated. You're in a car accident. You're now in a hospital and you're not able to manage your affairs on your own. Who's going to be able to access your bank accounts? Who's going to be able to make medical decisions on your behalf when that doctor comes out and is looking for somebody to say, this is what's going on and we need permission to do this procedure? Incapacity can strike at any time, can happen to anyone. And this is one of the biggest areas that I think a lot of people forget about when they talk about estate planning. Planning for incapacity, making a decision of who's going to be able to take care of you when you're not able to take care of yourself. There's different documents for that. You can appoint somebody to be your durable financial power of attorney. You get to designate the agent who's going to be managing your finances, stepping in, paying bills on behalf of you, making those important investment decisions when you're not able to do so yourself. And for some of us who have accumulated money over the years, you want to be able to know who is going to be in charge of managing that money and watching over it to make sure you're getting the best care that you want or you need. There's a durable power of attorney for health care. That's letting you appoint who is going to be the individual on behalf of you to make medical decisions. A lot of people will think, well, that's okay. I know if somebody comes out, the doctors will talk to my spouse. But that's not always the case. There's privacy laws, and there's pieces that need to go into place. My mom went in for a procedure not too long ago, and my dad was out of the country. So they were looking for who can act and make decisions on behalf of my mom. Luckily, I had her power of attorney in my hand, because me being the daughter sitting there, they may not have taken direction from me. And then the directive to physicians or the living will, that's you putting your instructions in place for end-of-life care. Do you want hydration? Do you want nutrition? This keeps that decision from having your family members needing to make that decision. And it's a tough one. And there's situations where you can have multiple family members, and those multiple family members can have differing opinions on what is the best care or what steps should we take. This takes that emotion and that conflict out of it. You're putting that in writing and you're putting your wishes down on what you want to see happen. So incapacity is a big one, and that's one area where when you think about your estate plan, definitely think about who do I want in place when I'm still alive but not able to take care of myself. So a will. What is a will? It's the cornerstone of your estate plan. It is where you're going to provide information on what are my assets, who are my beneficiaries, who's going to receive my assets and when will they pass, and who's going to be in charge of passing those assets on or overseeing them. You get to choose your executor or your personal representative. You can choose an individual. Maybe you have a family member that you know is capable of settling your estate, or you have a good friend. There's professional fiduciaries and trust companies that can step in if you don't have anybody that's able to do that. It's a lot of work. We oftentimes get people coming into our office saying, wow, I was listed as executor in my parents' will, and I had no idea what I was getting into. It's a lot of work. So when you do think about who you're going to appoint, keep that in mind. And I always tell people, don't surprise people. Have the conversations and let them know, hey, I'm doing my estate planning. I need an executor to settle my estate. Is that something you're going to be comfortable with? And that way you know from the get-go whether or not it's a task A, they want to do, or B, that they're even able to do. Minor children. For anybody who has minor children, it allows you to appoint a guardian to make sure you are in charge of who's going to be raising those children when you pass away. And then you can create testamentary trusts for your beneficiaries, and Neil will go into that a little bit later in the presentation and talk a little bit more about the trusts and how they're structured and how they can help fulfill your plans and wishes. So when you put somebody in that position of being an executor, They are actually a fiduciary. They have a legal liability. If I am an executor of my parents' estate, I have to take off daughter hat and I have to put on fiduciary hat, which means I'm there to carry out the purpose and the instructions that my parents put in writing. I may not necessarily agree with it, but I have to be loyal to their wishes. I can't take sides. I have to be impartial. I can't go over here and say, you know, I'm really closer to this sibling, so I'm going to get their feedback on everything and cut this sibling out. It's my job to be impartial throughout the whole process. I need to file the will with the probate courts and go through all those steps, and then collect the property and protect it, changing locks on places, on houses, making sure the houses continue to be properly insured. Murphy's Law will kick in the minute you let that homeowner's policy lapse. Something's going to happen at 12:01 a.m., and if you're an executor and you didn't insure that property, you could be held legally liable for the damage caused to that property. And then file the creditor's notice to put the notice out there to creditors that this individual has passed away, and start the claim period to where they could come back and receive payment from the estate. An executor also has to estimate the tax liabilities for the deceased individual. And when I say tax liabilities, there are estate taxes. You know, Washington State, you're exempt up to $2.193 million, almost $2.2 million. If you're over that, there are estate taxes that could be due anywhere from 10 to 20% based upon how far over the estate tax limit you are. Federally, it's at 11.4 million, but as an executor, you have to understand those tax liabilities and know the appropriate tax forms that need to be filed. And then you would prepare the necessary returns. There's a federal estate tax return. There's a Washington estate tax return, if applicable, so if you go above those two limits that I just talked about. The decedent's final income tax return, and then the estate has a tax return. So there's a lot of tax work that needs to be done, and not all CPAs and not all tax professionals do estate tax work. So it's making sure that you're working with the right individuals. Then you prepare the final accounting and submit that to the courts. That's where the courts are going to look over those accountings and give the okay that everything has been settled appropriately, distribute the assets, and then you close the estate. Sounds really simple, but it's not. You know, there's pros and cons to probate. You know, I hear a lot of people saying, well, I want to avoid the probate process. I need to create a structure so I don't have to go through probate. Well, the time and costs to probate a state are typically, you know, pretty modest. Here in Washington State, there's a flat filing fee. King County and Snohomish County, it's $240 to file the will with the courts, which, you know, if you look at that, you're getting the court oversight. That's not a lot to have that oversight of somebody making sure, as the fiduciary, as that person who's legally liable, you have everything in order and you're doing everything correctly. There's also that protection against creditors. I mentioned filing the creditor's notice. If an individual passes away and you don't file that notice, those creditors could come back and try to make good on that claim for 2 years. The probate process will shorten it to 4 months. You know, a lot of people say that it can be time consuming. That's a con because of title transfer delays. What kind of title transfer delays are there? Unique assets, if there's real estate. That you're having a hard time selling, maybe nobody wants it. That could add more time to the probate process. Ancillary probate, going back to when I talked about if you have property in multiple states, so you have a house here in Washington, you have a vacation home in Arizona. There's 2 probates that you have to do. And then it's public record. You know, it's out there, and some people don't want their estate being public record.
And Rochelle, let me just jump in for a moment and say just an interesting factoid. So in April of several years ago, when Michael Jackson died, what was the #1 internet Google search? Can anyone just take a gander? How much was he worth? That was the #1 Google search. And so when people went to pull it up and reporters went to look, he had a will, and his will said, "See my trust," which is private. By contrast, Marilyn Monroe's will is out there on the internet, and all of her personal information is out there. So that just gives you a sense, a real sense of just how public that is when you go through the probate process.
So can you avoid probate? You can. You can set up your estate plan to control that. Any accounts that you have where you have a joint with rights of survivorship, or if you list the beneficiary designation on your retirement account, life insurance policies, those will pass outside of probate. If you make lifetime gifts, so you're giving money away while you're alive to your family members, that would get that out of your estate, so there would be no estate to probate. And if you use trusts. Keep in mind, you can avoid probate, but that doesn't get you out of having to pay estate taxes. So two separate things. A lot of people think, well, if I don't have to go through the probate process, I don't have to pay taxes. That's a myth. So we're going to hop right on into trusts.
Okay. So a trust, in its simplest form, is simply a contract between you and yourself, not schizophrenic, so let's be clear. It's just between you and yourself for the benefit of someone else. One of the key purposes of a trust is to title assets into the trust name during your lifetime so that you don't have to go through the probate process, because that's one of the primary purposes of probate, is the orderly retitling of assets to avoid a Hatfield versus McCoy problem within the family, okay? And so with that, you have a trustee. The trustee is the person that is charged with managing your vision and your values that you put into that document. And it can be an individual trustee or it can be a corporate trustee. Just to give you a sense of just how flexible a trust is, you can do pretty much anything you want to do except violate public policy. So if you're a fan of Kim Jong-un's leadership style, okay, he runs North Korea. If you're a fan of his leadership style and you want to create a trust to give money to him, some court will say that violates public policy. We clearly don't do business with North Korea, so they will disallow your trust. Now, that ridiculous example just gives you a sense of just how far out you can actually go in terms of the things that you can do in your trust. So there are two categories, two broad categories of trusts. There are revocable living trusts. They're trusts that you create during your lifetime. You can change your mind at any moment and make a change to it. You have complete control over the assets in that trust. And because you have complete control over the assets in the trust, it doesn't impact the way you file your taxes. In fact, it's primarily done as future planning. You're simply transferring those assets over during your lifetime so that you're not going through the probate process. So I'll give you an example, an analogy. If you think of probate versus trust, think about being on a highway and you've got like a fast pass on your car window, okay? And if you have a trust, it's got fast pass because title has already been transferred. So you bypass the probate process. When you have probate, while always necessary, it's like stopping right there at the toll booth and waiting to pay your interchange before you move on. So just remember that analogy. And so with a revocable living trust, you have continuity for asset management, because what happens if you become incapacitated? You want to have a plan in place. The lack of a plan means that the state gets involved, and usually you'll have to have a guardian of the person or a guardian of the property. And it could be a family member that steps in, or it could just be a professional person that's appointed who may not necessarily know what your wishes are. So why not state them yourself? It avoids the ancillary probate that Rochelle was talking about. Many people. So just to give you a little bit of background, I live in Tampa, and I do have to say the Pacific Northwest is one of the nicest spots in the country. Helps me to get away from the heat, especially with a lack of hair up here. And so if I decided, you know what, I'm going to move to Seattle, but I'm going to keep a house in Tampa, and I pass away, and I don't transfer that into a trust, I have got to go open up a probate here in King County and down in Tampa in Hillsborough County. And I've got to run both of those because of its location. So we help to avoid that. And of course, it helps to instruct how you want your assets passed to your beneficiaries. You could have different children, and each child, even if they come from the same parents, can be completely different. I should actually take a little poll here. Raise your hand if you agree with that statement. Okay? So all of you understand. So some children can handle the money. Some need more time, and some simply cannot. And so you want that flexibility. Now, the second broad category of trusts are irrevocable trusts. So, again, you create the trust for the benefit of a third party, but with this one, you cannot make a change to that trust. Once you've done it, it's done. So because of that, it has now become its own legal entity. It has its own tax ID, and it files its own tax return. Okay? So an example of that could be, you could have a will, and inside your will, it could say something to the following effect. After payment of my last expenses of my estate, I want the remaining assets to go into a trust for my son or my daughter. And that is a trust that is inside of a will, so they call it trust under will. Okay? And it's irrevocable, of course, because you've passed away, and it would be really scary if you can make the change at that point. Okay? Or during your lifetime, you can simply create an irrevocable trust. Doesn't have to be connected to a will. And some people do that, and I'll talk a little bit about it, because they're trying to reduce the asset, take away those assets from their estate so that they don't hit the threshold for estate tax. Okay? Whether that be at the federal level, which is about 11 point something million, okay? Or at the state level, which is about 2.2. So if you're concerned and you want to shift some of your assets to help avoid some of the estate tax, which can be as high as 40% of your funds, then you'll shift it over into an irrevocable trust to move it outside of your name. And so some of the benefits, you have the trust for your beneficiary. You can provide for asset management, which includes investment management and then distribution of those assets periodically. It can protect a minor so that those funds don't necessarily have to go through a conservatorship with the court system. You may have an elderly beneficiary that is susceptible to financial abuse, and it can help there. Or simply, as Rochelle had noted a little earlier, there may be spouses that really don't feel comfortable with the responsibility of managing money. And so you can create a trust so that that spouse can have access to funds, but also access to professional advice and assistance working in partnership with the trustee. And of course, when you create a trust, your voice is heard because the trust represents your values, what is important to you and why. And so how much you choose to give, who you choose to give it to, how you choose for them to receive it. They all reflect your values. And so that is expressed in that trust document. And when you think about protection, you could have a son that's a really hard worker, but loves to go to Vegas. And has got some really great friends in the high roller suite. Okay? I'm just saying. Or you could have a child that gets married and then they go through a divorce. A trust keeps that asset outside of the marital estate and it's not commingled. So that in the event of a divorce, your hard-earned assets don't get swept up in that process and potentially divided. Special needs trusts. I always say every single trust should have special needs language. And what that means, very specifically, is it's language that basically says that in the event that my beneficiary becomes disabled and needs public benefits, I don't want the monies from this trust to disqualify them from those public benefits because it would be seen as an asset. And quick quiz question. What's the #1 reason for bankruptcy in the United States? Medical expenses. What's the quickest way to deplete the money that you've saved? Paying for medical expenses. So, in many cases, where you have a disabled child and you want that disabled child to benefit from what the state can provide while also supplementing the quality of their life with money from the trust, a special needs trust helps to do that. It helps to prevent them from having their benefits disqualified, but knowing that that money is there as a safety net to help them. And then, of course, people use trust for the reduction of estate taxes. So the exemption equivalent trust and a qualified terminable interest property trust, otherwise known as a Q-tip, are two types of trusts in which the spouse, the deceased spouse, provides income and access to principal for the surviving spouse, but the surviving spouse cannot control the direction of those funds, the disposition of those assets. And that's significant because if the surviving spouse cannot control the disposition, the direction of those funds, it's not includable in their estate. So then therefore, you're helping to shelter assets from the estate tax. So, very quickly, a trust deed IRA is a mouthful. What I would tell you is this. Think of it as the IRA that you know, okay, with a cape, because it can do a lot more. So, for example, a traditional IRA will tell you who you can leave your money to. And then it will also give them the option of rolling it over if it's a spouse, or stretching it out over life as Congress had intended. A trust deed IRA basically says who you can give it to, when they can receive it, and how they can receive it. So just remember the who, the when, the how, and we'll go over that in the next slide. Just like a regular IRA, same rules apply. You, as the IRA owner, retain absolute control, so you can make changes anytime you want. And it provides for incapacity protection, so that, like a trust, in the event that you become incapacitated, then it provides for ongoing management without the intervention of a court appointing a guardian. So, let's walk through it. With a standard IRA, technically known as a custodial IRA, you name your wife as a beneficiary, or for some of you, you name your husband. That spouse legally has the option to roll it over into their name. And in doing that, they can take it as their own. And they can redo the beneficiary designation and control the disposition of those assets. Now, if you have a blended family, perhaps, and this is uncomfortable, but it's a reality, a spouse can actually just write out a Benny. I'll give you a quick example. The scene is at the wake, okay? So previously, the husband and wife, some years ago, sat down in the evening, like many couples do at the end of the day, and they kind of pulled together, they gathered, they had their conversation, and one spouse said to the other, "Sweetie, I love you, you're the love of my life, I love our family, please treat all our kids equally, God forbid something should happen." And the other spouse says, "My heart, absolutely." Fast forward several years later, we're at the wake, the child from the first marriage makes a snarky comment, and the surviving spouse goes, "You know, I've had enough of you. You're an ingrate. I'm done." And they roll it over, take that person out, and the whole estate plan is gone out the window. That's a real life scenario. Now, with a trusteed IRA, you name the wife. The wife gets the RMD just like they would normally, can even get more than the RMD if needed, but does not control the final disposition of those assets. So that conversation stays intact, and that spouse also gets the benefit of that IRA. So a powerful tool. The wife has no ability to change the remainder. If needed, the wife will receive additional monies based on a standard for her health or his health, their education, their maintenance, or their support. So again, your spouse is provided for. And so I'll turn it over to Rochelle.
Okay, so what happens if all of you walk out of this room and you don't have an estate plan, and you never do a will, you never do anything? If you've listed beneficiary designations or you have joint accounts with rights of survivorship, those items will pass, but all of your other assets will go through the state law's intestate statute. So Washington State has a plan for you. It may not be what your plan is, but if you passed away, if you have a spouse, your spouse will get a portion of the community property and a portion of the separate property if you have children or parents still surviving. If you have neither, the spouse can get all of the property. If you have no spouse, there's a plan that it looks down to your children. If there's no children, it goes up to your parents. If there's no parents, it goes to siblings. If there's no siblings, it goes up to grandparents, and so on. Once they can't find that distant cousin that lives out of state that you never knew, then Washington State has a plan, and they're part of your estate plan. So the conclusion, have you implemented a plan? Do you have a will in place? Do you have any power of attorneys? Do you have an estate plan? Is it what you want? Have circumstances changed? Do you have to go back and review it and see if anything needs to be changed while you still have the capacity and the control to do it? Is estate tax planning a valid concern of yours? And do you have to go back to your attorney and say, wait a second, I don't want to leave 40% of my estate to taxes. What can I do, and how can I structure this to make sure that my family and my loved ones are getting the benefit that they should receive? And again, does your overall estate plan reflect your wishes? I always tell people, you know, we take our cars in for regular maintenance. If something changes, we go in and make sure that car is looked into. Same thing with the estate plan. If something changes, you have a grandchild that's born, your child gets married and you don't like who they marry. You know, your child gets divorced. Pull out those plans and review them and change it while you still have the control to do so. So this is our disclosure language. We're not attorneys. We're not tax accountants. This is for educational purposes only, so we would encourage you to seek the professionals for the actual advice. In the packet that you have, there is a sheet, an evaluation form to fill out. Please fill that out. If you would like to have us reach out to you to set up a time to talk more in depth, you can put that on there as well. So does anybody have any questions for us? Yes.
Hang on just a moment, please. We have a mic runners.
Getting some cardio there.
It's on.
In case of a joint account, any checking or savings account, it's either a survivor. If one of the account holders dies or passes away, is there any action to be taken by the other person, or you can simply get the entire funds available in that account to himself or herself?
If it's joint with rights of survivorship, there's some financial institutions where they have the option of an account without rights of survivorship. So you'd want to confirm that with the credit union to make sure it's set up appropriately.
So, and then where it has a JT, joint tenancy with right of survivorship, it automatically, by operation of law, goes to the surviving spouse. So you wouldn't have to do anything. But to Rochelle's point, on the actual card or application, you want to make sure that it provides for joint tenancy with right of survivorship.
One thing I want to bring up that, got me thinking when you said that, we meet with a lot of family members who say, well, I put my daughter on my checking account, my savings account, just for continuity purposes, and if anything happens to me, they can get in and handle my assets and take care of those financials. Keep in mind that if you pass away, there's a potential that account can go 100% to your child if it's set up as a joint with rights of survivorship. If you have 2 or 3 children that's supposed to be split evenly among, it's legally belongs to that child that's on the account. So those are things that you want to keep in mind.
Yeah, and just to that point, whenever you have joint account, just remember that it is subject to the creditors of the other account holder. Okay? So that if you have a child on a joint account and they have a creditor issue, those assets in a joint account are actually open to creditors' pursuit.
We have another question?
So I just want to see if I understand this. So if you think your assets are under the 2.2 for Washington State, and you have a will, and you have beneficiaries on all your IRA or whatever investments you have, then it sounds like you don't necessarily need a trust. But when it goes above that, then you may want to consider that for tax reasons, or if you don't like who your kid's married. Right?
Well, not quite. So, usually when people do their beneficiary designations, they do them at discrete moments in time. But let's say in your mind, you want all of your children to have an equal amount. So you have 3 accounts with 3 different beneficiary designations that may have had the same value on day 1. But over time, those values may fluctuate. So if you don't continuously update and coordinate your beneficiary designations, your plan, the outcome will not reflect what your intention was. So that's one example of why it's something that you need to stay on top of if that's the route you go. But taxes are actually a small part of the reason why you would do a trust, because you may just have complex planning, and complex planning involves personalities. It involves different needs. It involves protection of bennies, sometimes from themselves, and it also provides for contingencies, like someone having an accident and disability or incapacity.
So you can go to BECU and explain what you have and get advice as to what to do from there?
We can educate you on the different type of tools there are and options that you have. Now, we're not attorneys, so we're not there to draft the documents for you, but we can help give you that information so when you do go to the attorney, you can have that conversation and really understand the type of path you want to go down with your plan.
And what was your role with BECU?
Sure. I'm the General Counsel and Chief Fiduciary Officer for Members Trust. We're a partner institution. We're actually a national trust company. We partner with BECU Trust Services, and we work together to provide the services locally.
So you could go to BECU, present your individual situation, and if it seems advisable to go to a trust, then go to your organization.
No, you actually would work with Rochelle or some other team member throughout the whole process, because they have the capability to do all of it.
To do the trust? I thought?
Right, but they work with us. The only thing that we do not do is we don't actually draft the trust, because that would be the practice of law, and we're not a law firm.
Okay.
But when you're talking with Rochelle, or that's Amy, or you're talking to other people within the organization, think of them as a concierge. They're someone that helps to carry you through the process, because it is very unfamiliar for a lot of people. And so one of the benefits of talking to Rochelle and others is that they're helping you to identify issues, to get clarity, and to have, you know, a more appropriate and tailored estate plan.
And do we pay for that?
No,
That's part of our fee?
that's part of being a member.
We have one more question up here.
Along the same line, I've seen trust CDs at Costco. Are they any good?
I can't speak for the trust CD at Costco. I don't know much about their product.
I mean, would it still be valid, you know, if we fill one of those out?
Well, so just to be clear, a CD trust is very similar to pretty much any CD that you would get, you know, whether it be at BECU. Rates are going to be different, of course. So that's something to keep in mind. But that you would put a beneficiary down, and that would be beneficiary designation. It's a little confusing because when they say a CD trust, it's not really a trust. It's just an account that has a beneficiary designation.
I think he's talking about a will maker CD.
Oh.
A document maker.
Oh, the document preparer.
Yeah, Neil was going.
Okay.
Yeah.
So I just had this, I work at BECU Trust Services. I'm the VP and head up the department. And we just had this conversation earlier before the seminar started. So online planning, the difficulty part of that is that there's a lot of dialogue that you can't have with an individual professional to talk about family dynamics, to talk about personal property, and to talk about all the various options that you could have in the disposition and the planning of your estate plan. You don't get that dialogue with a CD or with an online service. And I would venture to say there's not anyone in this room that doesn't have some sort of family dynamics. We all do. And so I would love that if we didn't, but the reality is we all have family dynamics. And those online programs or CDs do not have that conversation with you on the what ifs, or here's why maybe you shouldn't appoint two people as your attorney in fact, because what if they don't agree, right? If you have your son and daughter and you appoint both of them as your attorney in fact, and each person is an individual and they have their own ideas of what is in the best interest of mom or dad, that's where the friction starts, right? Because they're not going to agree. You're not going to get that dialogue with a CD or an online program, okay?
Okay, I think we have time for one more question, and then afterwards we'll be here and be able to answer more questions for you after the.
How to ensure that the professional we are going to is reliable?
No, it's a very good question. Yeah, exactly. So when you say provider, do you mean the trustee or the attorney? Both. So with a trustee, you certainly, a professional trustee like BECU Trust Services, they're regulated, right? They're part of a larger institution. You can look at their underlying qualifications as professionals, so those are all things. With regards to attorneys, you want to look at attorneys that might specialize in that area. So a good percentage of their practice is focused in on drafting trusts and wills. That's very important. You don't necessarily want to get someone that does it 10% of the time. Right, exactly, and you can check with the Bar Association. Also, you know, the team at BECU Trust Services has developed relationships with quality attorneys throughout the Seattle area, so you can certainly come and talk to them, and they can help to make a referral for several attorneys for you to investigate.
Okay. One more? Do we have time for one more question? Okay, good.
Special needs trusts,
Yes.
which I know you like.
Yes.
Simple question. Is the only point of a special needs trust is so that you can apply for Medicaid?
That is the, that.
So you, because you've split your estate, one of the partners, half the estate's gone into the trust. So that once the other partner has used up all the remaining money, because they can't touch the trust, they apply for Medicaid. So is that the only point of a special needs safe harbor trust?
Yeah, so I don't know if Linda, you want to jump in, but the primary purpose of the special need is so that you can preserve assets in order to qualify and then extend out the value of those assets to be there as a safety net and to supplement. Because with Medicaid, you can only have a certain amount of money. Okay, that's right.
Yep.
That's right, 2,000 in resources. And you can't get cash because that's unearned income, right? But through a trust, you can pay third-party providers, and there's a lot of different ways to have that money be used for the benefit of that special needs beneficiary that raises the standard of their living without triggering those benefit rules.
Yeah, but if the remaining partner has any income stream at all, then there's no point to it.
Yeah.
If they, correct, if they have an income stream that trips over, yes, it could be an issue.
But here's an example. So my daughter, I have an 11-year-old daughter. I only have one child. She has OCD. And so she has a mental disorder. And so for her, when my husband and I pass away, any assets that we have left will go into a special needs trust for her benefit so that, yes, she could qualify for state assistance. And the important part of that is the medical expenses. And then the trust would be to improve the quality of her life, right? So there's different reasons for these types of special needs trusts.
Well, thank you, everybody.
Absolutely.
We appreciate it. We'll be around to answer any specific questions. Again, if you want to talk more one-on-one, there's the evaluation form, and we also have a booth outside, too. So thank you.
Thank you, everybody.